so that we could implement fostering futures. But we were not successful in getting the bill language passed. That means the authority for fostering futures is not actually in the Virginia Code. However, the state legislature put it in the state budget, which does give Virginia Department of Social Services the authority to move forward with implementation. In the budget appropriation language, we were directed to set out the requirements for the program, and we were provided with the funds to be able to do so. The budget language includes what's called an enactment clause, which essentially says that this program is only available for youth who turn 18 on or after July 1, 2016. So we were not able to go backwards and grandfather in youth between the ages of 18 and 21 who had previously aged out of foster care. We were only able to implement the program going forward. And that's what this enactment clause means. So if a youth had their 18th birthday in June of 2016, they would not be eligible for this program. But all youth in foster care turning 18 from July 1 forward will be eligible. The basic requirements of the program is that the young person must have aged out of foster care. What that means is that they turn 18 in the custody of a local Department of Social Services in Virginia. The one exception to that would be if they had been in foster care immediately prior to having been committed to DJJ, and then they leave the, shouldn't use acronyms, Department of Juvenile Justice. Then they leave the Department of Juvenile Justice correctional facility after the age 18, but before turning 21. And that's because another requirement of the program is it's only available to young people between the ages of 18 and 21. All of the participants must sign something called a voluntary continuing services and support agreement. The youth are automatically in the program upon turning 18. The agreement spells out what the requirements are for the program that the young person is agreeing to, because it is a voluntary agreement. But the agreement also serves a special purpose in allowing the young person to sign themselves back into foster care. So as an adult, they can't be in the custody of the local department because adults can't be in the custody of another adult. But this agreement is a legal document that essentially says the young person is entrusting themselves back into foster care with the local Department of Social Services that had their custody prior to turning 18 for the purposes of receiving foster care services. So that agreement is a formal agreement that must be approved by the juvenile and domestic court. The Continuing Services and Support Agreement initiates a new foster care episode. And the reason that this is important is because it allows us then to evaluate the new foster care episode for federal funding eligibility, for the Title IV-E federal funding eligibility. This eligibility at this point is determined based on the young person's income, not their family income. So for all the children in foster care, our 4E versus state funding is about 50%. It goes up and down a little bit, but it's around 50%. For this population, we anticipate that upwards of 75% of the participants will be eligible for federal funding. That's because young people at the age of 18 generally are not making a significant amount of money. Most are full-time students. If they are working, they're working low-wage jobs. They're not working full-time. So we anticipate that the percentage of our young people who are eligible for federal funding is going to be quite high. Once they're determined eligible after signing the agreement for the new foster care episode, then their eligibility doesn't get reviewed again unless they exit the program and come back at a later date. We'll talk about that a little bit later. For young people to continue to be eligible after entering the program, they need to be meeting one of these 5 criteria. I'm going to talk about each of them a little bit more, but I wanted to show you what all of them are. The first 2, completing secondary education or in a GED program and enrolled in college or a vocational program, are conditions that we have currently for our young people receiving IL-only services. But the other 3 are new, and so I want to spend a little bit of time talking more about how the federal criteria, which we've adopted for Virginia, is much more flexible and allows us to provide more of a safety net for our young people. So in regards to secondary education or GED, the intention is to allow these young people to finish high school. If they're attending classes, they're on track to graduate, we want them to continue in their school program. If they're in a GED program or they're entering a GED program, we want to support them because a high school diploma is really a major achievement for our young people. They do not, the federal guidance defines full-time secondary education or GED program as being enrolled. There's no minimum number of credits or hours that they have to be participating. They just have to be making progress towards completion. For a college or vocational program, this would include job training, any kind of vocational full-time or part-time program. It could include community college or 4-year university. It could include some classes or a full caseload. Some of our students need to take remedial classes before they can even take the basic general ed classes at community college. And so being enrolled in remedial courses would count for this. Again, there's not a minimum number of hours that they must be participating, but they need to be making progress towards something. And the plan can be a combination of things. So, you know, our goal is to support these kids to make a successful transition to adulthood. So if they're not prepared for full-time college, we would want them to take some college classes or some vocational classes and then also work and gain work experience. So their meeting the criteria can include a couple of different aspects. It doesn't have to be full-time, all one thing or all another thing. This third item, attending classes to promote employment or remove barriers to employment, is probably the most flexible of all of the requirements. We're really encouraging locals to look at this, particularly as a way to keep a young person eligible if they have an episode where things are not going well. So an example would be a young person who maybe enrolls at classes at the community college and after about 8 weeks is failing them all and ends up having to withdraw. So that would be a terrible time to make that young person ineligible to continue to receive support. They really need support probably more than ever. And what we would want to do with them then is figure out what else they can work on. What else can we support them to do? Can they work on getting their driver's license? Do they need to be in counseling to deal with some underlying issues that are getting in the way of their being successful in school? Do they need tutoring? Do they need to figure out what they want to do in school, what area they'd like to study? So they can meet the continuing eligibility criteria by doing an internship or volunteering, by participating in a course of counseling or working towards getting their driver's license or some other kinds of combination of things that ultimately will improve their ability to gain meaningful employment in the future. We also have on here participation in a substance abuse program. Again, it would be anything that's a barrier to them gaining self-sufficiency, being able to be employed at a wage that they can make adequate money to support themselves and a family. The fourth area is working, and this is such an exciting thing to me. I had many kids that I worked with over the years who would finish a vocational or educational program or decide that school was not for them. They wanted to work, but they weren't able to go right out and get a full-time job. They often had to start part-time or start at a lower level, lower paying part-time job, which was inadequate for them to then pay their rent and their bills on their own. Under our IL only program, working doesn't count as an eligibility criteria. They have to be in school. So if they were transitioning out of school, they would no longer be eligible. Under Fostering Futures, we can help support young people as they leave a vocational or educational program and begin working, so they can gain work experience while we continue to help them, so that ultimately when they leave the program, they're better equipped to pay their bills themselves. The other thing is, if you have a young person who doesn't really know what they want to do and they want to work, try something, try several different things, work and go to school part-time, we can use this criteria to continue to have them be eligible for assistance. The last criteria is that the youth would be unable to meet one of the other 4 conditions due to a documented medical reason. We're encouraging locals to consider that this criteria is not, or this program is not really appropriate for supporting youth who have long-term significantly disabling conditions. If the young person is going to need a level of support or care and supervision that's beyond what they could ultimately be able to access on their own, then we want to make the effort to transition them to the adult serving agencies and assistance that's available in the community at the point that they're moving out of foster care. So if they need a legal guardian, we want to make sure that they have a decision maker to help them make medical or care decisions. If they need disability payments, we want to help them access the disability payments. If they need to be in a supervised or nursing care setting, we want to make sure that they have access to that, even if they're not in foster care. And so we've been working with the agencies to think about planning for that very small population of kids while they're still 15, 16, and 17. So as they're turning 18, they're transitioning into the adult serving agencies. This condition is important because it allows us to continue to serve kids that otherwise have a medical or mental health situation that might make it hard for them to participate temporarily. And so what the examples we're using are like a youth who's in a serious car accident and ends up in the hospital and then has to do physical therapy or maybe be in a rehab facility for some period of time afterwards. Under the IL only criteria, if they weren't in school, if they had to withdraw from their classes, we wouldn't be able to continue to find them eligible. Under Fostering Futures, using this criteria, we could continue to support them during the period of time that they're recovering. Another example might be a youth who has an episode in which a mental health condition is not controlled and they need acute hospitalization, or they need to do a partial day or some other kind of treatment program. That means that they have to withdraw from school or stop working for some period of time. And then the third example we've been using is a young lady who becomes pregnant and then has a complicated pregnancy and ends up on bed rest or something of that nature, where she might unexpectedly have to withdraw from classes or leave her job. That would be a terrible time for us to no longer support her. This eligibility criterion means that we can continue to help her with services and financial support until such time as she's back on her feet and the baby is old enough to be appropriately enrolled in a daycare setting so she can go back to school or work. Okay, so as I mentioned earlier, the participant has to sign a voluntary continuing services and support agreement, and the local department has to file a petition and write a new foster care plan and submit those to court. The court has to have a hearing within 45 days of the petition being filed, and the judge has to find that it's in the sorry, I shouldn't say kid, in the young adult's best interest to continue in foster care for the purposes of receiving services through Fostering Futures. We actually have a new court order that's called the Voluntary Continuing Services and Support Agreement order, and a petition for this process to happen in court. So once the judge has made that initial finding and we have the court order, that meets the requirement, the ongoing requirement for the 4E funding. There's no further court review required. However, the agency has to do reviews every 6 months. So the court may ask that the case come back to court. Some of our judges want to see how these young people do and make sure that they're getting what they need. They may schedule a 6-month review in court, but if the judge doesn't, then the agency is required to have something called an administrative panel review. These happen for some of our foster care cases for children younger than 18, but more often the reviews happen in court. So I don't know how familiar you all might be with the administrative panel review process, but essentially the team that's working with the young person comes together, the worker, the supervisor, the placement, whether it's a foster family or another kind of placement, and any treatment providers. And they discuss how things are going. Are the services correct? Does the youth need something else? The young person is obviously, I didn't say that, but the young person is part of that process, as well as two people who they choose to be their advocates can also be part of that process. So the local agency needs to have a formal review process at least every 6 months, where there's an opportunity to kind of evaluate how things are going and whether anything needs to be adjusted. That is documented then at the local agency in the young person's record, and that makes the case continue to be eligible for the federal funding. All right, living situations. This is very exciting. For Fostering Futures participants, there's essentially a couple of different places where they can live. The first is in a foster family. So under our current IL only structure, foster family placements were not allowed because those young people are not eligible for placement at all. But under Fostering Futures, young people can continue in their foster home. We have to do some paperwork because we have to indicate that it's a quote unquote new placement because it's a new foster care episode. We need all the dates to line up. But essentially, what we really hope will happen is that these young people will just stay where they are with the family where they've been successful to date. That is one of the major goals of Fostering Futures, is to be able to provide extended family support for these young people, not just money, but the relationships, the support, the encouragement, the care that they get while placed with a family. So they can live in foster homes. They can live in a college dormitory or some kind of setting where they're going to school, or they can live on their own. And in the on their own category, there's a lot of flexibility. They can live in an apartment, they can rent a room, they can live with their spouse, which we never used to allow, but the feds allow. They can live with an extended family member. That might be someone who we couldn't have approved to be a foster parent for them, but essentially they're going to pay rent and stay, with an uncle or a cousin or a family member. They also can live with their bio family. We have a lot of agencies who are really struggling with this. So we remove a child from home, they're in care for a number of years, and then they turn 18 and they want to go home. And previously, the local agency would have told the young person, if you go home to live with your parents that you were removed from, we can't continue to support you. But under Fostering Futures, we want these young people to have a safety net. So rather than telling them, if you go home, we're not going to continue to support you, what we're telling them is, these are what our concerns are. you need to have a school program. You need to be working towards something for us to continue to support you. And you need to be in a living arrangement where you're going to get the support that you need to be successful in your vocational or school program. And so we're worried about this, where you're choosing to live, because that may make it harder for you to be successful in school or vocational. But we don't tell them that they can't do it. We do not give the birth parents any money, but the young person would get a stipend. It's actually the maintenance payment that foster families get, the young person would get directly, and they can use that money to pay rent to whomever they're living with, and to meet their own expenses while they're living there. So we wouldn't give a maintenance payment directly to the birth family, but the young person could use the maintenance payment which they're receiving to pay rent to live there. And then we would keep working with them. So if that arrangement turned out to be a disaster, they would have an opportunity to change their mind and come back or try something different. There is also no prohibition on them being in the military reserves. That's sometimes a great vocational option for young people and a way to earn some extra money. And they also can be in the Job Corps or in a vocational school where they might live on site. They are not allowed to live in group homes or residential facilities. Those are the two placement types that are not permitted under Fostering Futures. There are two special circumstances which we've been talking to the local departments about. There is nothing about being in the active military that's against the rules, but if the young person is in the active military and they go to boot camp and then they go off to Afghanistan, they don't really need the Fostering Futures program at that point. And so we would close their case. We would encourage the local department to close their case. The good thing about Fostering Futures, and I'll talk about this a little bit more at the end, is that just because the young person's case closes, it doesn't mean they can't come back later and access services. So let's say they go off for a year and then they come back and decide they really want to go to college and they'd like to be able to access some additional support from the department. They could come back at that time and access that additional support. Long-term incarceration is a similar situation. A young person ends up being sentenced, they're going to be away for 2 years. There's not a lot that they're going to be working on in terms of transitional planning during that period of time, and the department's not really in a position to help them considerably during that period of time. So we've closed their case, but if they're released from incarceration before they turn 21, they could still come back to us and access services at that time. We've been talking to the local departments about not closing kids' cases if they get charged with something and go to jail, because during that period of time, we have a rule that people are innocent until proven guilty, and the young person might actually benefit from increased support during the period of time that issue is being resolved. So just, because a young person is charged with something or spends some period of time in jail, that's not an adequate reason to close the case. The local agencies have to decide on a case-by-case basis what they want to do, and not what they want to do, but what they can do to help. And as long as they're providing a safety net, the case should stay open. At the point that they no longer have anything to offer the young person, then we're encouraging them to close the cases. We have one exception regarding a group home and residential, and that is if we have a young person who is in group home or residential setting and they're on track to graduate before they turn 19. When we started writing the policy, we realized we had a fair number of kids who, might be a month away or 2 months away from graduating at the point that they turn 18. We don't want this population served in group homes and residential. We really want them to be in foster homes prior to turning 18. But if they happen to be in a group home or residential, we also don't want to propel them out of that placement just because they have a birthday and then put them in the position of not graduating graduating or having it take an additional year to graduate. So we did make an exception in the placement rules to allow for youth who are in these placements that aren't allowed to actually stay in foster care, but not enter fostering futures immediately. So the feds allow an exception to continue to provide foster care services to youth who are on track to graduate before they turn 19. And then at the point that we know that they're not going to graduate, or at the point that they graduate, in Virginia, those kids are going to immediately transition into fostering futures and out of the group home or residential program and into a placement that's permitted by the fostering futures program. So maintenance payments for children who are younger than 18 are intended to cover the participants' costs for food, shelter, clothing, supplies, and personal incidentals. Under fostering futures, that is exactly the same now for young people who are over 18. We're using the rate for young people 13 and over, which as of July 1 is $700 a month. And for youth who are living in an IL arrangement or an independent living arrangement where they're paying their own rent and for groceries and other expenses, the maintenance payment can be paid directly to the youth. This is new because currently maintenance can only be paid to a placement, to a foster family or a group home or residential program for children, for kids who are younger than 18. And kids over 18 are eligible to receive an IL stipend. That's the IL only population can get this IL stipend, which is a service rather than a maintenance payment, which means that it can't be paid for with federal money. So under the new program, the federal money can be used to make the maintenance payment directly to the youth. So even young people who are in independent living arrangements can access that federal 4E funding. Enhanced maintenance is an allowable expense for this population. So if the young person is in a foster home where enhanced maintenance is part of the foster home placement, that enhanced maintenance will continue after the youth enters the Fostering Futures program. They're also eligible for the annual clothing money. This again is new under the IL only rules. The young people were not eligible for clothing money after they turned 18 because they were not receiving maintenance. And for young people who have children, who have a minor child of their own, under regular foster care rules for a young person under the age of 18, the department can make a maintenance payment for the minor child of a foster care child. But what used to happen is when that young person turned 18 and became eligible for the IL stipend only, a maintenance payment was no longer available for their own child. So now the maintenance payment will continue to be available for the minor child or children of the Fostering Futures participant, as long as the Fostering Futures participant has custody of that child and that child is residing with them. So we kind of joked in some of our trainings about if you have two young people in foster care who happen to be the parents of the same child, only one of them can receive the maintenance payment, whichever one that child is living with more than 50% of the time. All right, so the local departments are required to do the monthly face-to-face visits with the participants. This is a new requirement. Under the old rules, the worker only had to see the young person once every 3 months face-to-face, but now they have to see them every month face-to-face because this young person is in foster care, not just independent living. But they will also continue to do the IL skills assessments and develop transition plans with the young people. These are important because these are how we're going to encourage the young people to plan to take advantage of the Fostering Futures program. We're going to talk with them about their goals and what the department can do to help them reach those goals. There has to be an ongoing foster care plan that the participant is actually actively involved in developing. We have to continue to talk with the young person about permanency and family connections. Those are all requirements of the federal program. And then any services which are needed for the young person will continue to be presented to the local family assessment and planning team, or FAPT. The maintenance payments are all part of the federal program, but any services which the young person needs in addition have to be approved through the local FAPT. Okay, exiting from fostering futures. Kids, young people can exit from fostering futures in two ways. The first is that the young person says that they don't want to be in the program anymore. Under fostering futures, the local department is responsible for providing 30 days written notice before ending payments or services. So if the young person says they want to leave, the LDSS is required to respond in writing, informing the participant of the consequences of leaving, everything that they'll lose if they exit the program, and also to provide them with the information about how they can re-enter the program at some point in the future prior to reaching the age of 21. And then the LDSS has to continue paying for payments and services during the 30 days period in order to give that young person an opportunity to change their mind. We're really talking to the local departments about this being a period of time in which they should continue to actively try to engage that young person and help them really think through their decision. The young person can change their mind at any point during that 30 days notice, and their case doesn't have to close. But if at the end of 30 days they either haven't responded to any attempts of communication from the worker, or they haven't indicated that they're going to change their mind, then at that point payments and services are suspended and the case will be closed. The second way that participants can exit is if it's determined that they're no longer meeting the eligibility criteria. And again, under this circumstance, the local department needs to notify the youth in writing that services and support will be discontinued in 30 days. We want the young people to be aware that this is happening and have time to get back in compliance or change their minds during this process. They also have to be notified about their right to appeal termination. So if for some reason, I can't even really think of a good example. We did become aware a young lady was going to college and her worker left the agency, and somehow the new worker was not ever provided with good contact information for her. So the agency closed her case, but they had never talked with her about that. And she was able to successfully appeal the termination of her services and get those restarted. But that's a very unusual circumstance. Under most cases, the youth is aware that they're not doing something they're supposed to do, and that the agency is trying to work with them to help them get back into compliance. And they, either are choosing not to, or moving on at that point. But the agency will be providing them with the procedures for appealing the termination. If the young person is placed with a foster parent, the foster parent also has a right to appeal the termination of services. So that might be something that is of interest to you. Again, in these circumstances, the LDSS has to provide information to the young person about the criteria and procedures for re-entering the program at some point in the future. Although the locals are required to give 30 days notice, if the young person leaves placement, the LDSS can't actually continue to pay for the placement for 30 days. But the idea is that if the young person is in an apartment, that the agency wouldn't stop the maintenance payment so abruptly that the young person wasn't able to figure out a plan for how to pay the next month's rent while they were figuring out what they were going to do next. If they're in a placement, however, we're bound by other rules that we can't continue to pay for a placement if the young person's not in it. If there's a situation where a young person declines to participate in Fostering Futures anymore, but is still living with their foster parent, we would pay the services for 30 days and then close the case. But there would be plenty of opportunity to discuss that with the youth and the foster family during that period of time. Hopefully that wasn't too confusing. Reentry. This is probably the most exciting thing about the Fostering Futures program, in my opinion. Under the current rules, young people can receive independent living services after they turn 18 through the local department, but only until such time as they leave the program. So if a young person who's not eligible for Fostering Futures turns 18, let's say they finish high school, but then they're done. They don't want any more services. So they tell the agency, I don't want any more services. I'm leaving. I'm going to get an apartment and a car. Everything's going to be fabulous. They leave. They have 60 days to change their mind. If they don't change their mind in the 60 days, then the agency closes their case. If they come back to the agency on day 75 and say, I'm homeless, my plan for who I was going to live with has not worked out at all, I have no car, I have no job, I have nowhere to live, I really need help, there's nothing that that local agency can do at that point. Their case is closed and it cannot be reopened again. Under Fostering Futures, we changed that. We changed it so that the young people are in the program automatically by the nature of turning 18 in foster care. And then they can exit and re-enter the program as many times as they need to between 18 and 21. We can't provide them with services after they turn 21, but if a young person at age 18 makes a terrible decision, blows out of school and placement and declines to participate, and then after 6 months decides that's not the best idea they ever had in the world and wants to come back to the agency can have them sign an agreement and go to court and get the court order at that point. If they are in the program for a year and then leave for a year, they can still come back when they're 20 until they turn 21. So the best thing about this program is that it really provides a true safety net in the sense that the kids are not consequenced forever for making a bad decision, particularly right around the time they turn 18. The court order is a requirement for federal funding. And so if the young person signs the agreement, we go to court and we get a court order, and then the young person exits the program. If they're gone from the program for more than 6 months, we have to go back to court to get a new court order. It's not a barrier to reentry, it's just a requirement for the federal funding. If they come back before 6 months has passed, then they don't have to go back to court. The agency can just have them sign a new agreement. They can renegotiate the terms under which the young person is going to be receiving services. The young person says where they're going to live and what they're going to work on, and we can proceed. But we have to get a new court order if the young person has been gone for more than 6 months. Okay, I mentioned this at the very beginning. One of the things about Fostering Futures, which is wonderful, is that if a young person, let's say when they're 17, they get convicted of a juvenile crime and they go to the Department of Corrections for the Juvenile Justice Department for kids, and they are in the juvenile justice program until they turn 18 and a half. They're now able to come out and enter the Fostering Futures program. So at any point that they're released after having been in foster care at the time that they were committed, if they're between the ages of 18 and 21, they're eligible for Fostering Futures. They have to indicate how they're going to meet one of the eligibility criteria, what their plan is for school or vocational training or working or some other kind of program that's going to help them to ultimately become a more successful adult. But they can come out and get a full array of placement and supportive services, just like a young person who turns 18 in foster care, which is really good because these young people need a lot of support. Most of these young people will live in independent living arrangements rather than in foster homes, but if they have a foster family or a relative who can be approved as a foster family, they could be placed with a foster family after leaving DJJ. Okay, adoption assistance. So there is a category of young people for whom Fostering Futures will allow us to extend adoption assistance. It's not a very big category because most of our young people are eligible for the extension of adoption assistance to the age of 21 because they have a special needs criteria. They meet the eligibility for extension related to a special needs. Under Fostering Futures, however, if a child is adopted who is age 16 or older and turns 18 after July 1, when Fostering Futures went into effect, and they are not already eligible for an extension related to special needs, then they can be eligible for an extension related to Fostering Futures. So they have to have a school or vocational plan or be working. They have to meet one of the 5 eligibility criteria. The adoptive family is asked to file an annual affidavit indicating that the youth is still eligible, and adoption assistance will always be paid to the family, so that the young person can't be in an apartment and receiving the adoption assistance directly. But if it makes sense for them to be in an apartment because they're going to college somewhere, the adoptive family can continue to receive the adoption assistance and use it to support that young person to pursue their educational or vocational goals. Case management requirements do not apply for this population, just like with the other kinds of adoption assistance extension. And adopted youth are not eligible for reentry. We evaluate their eligibility once a year when the adoptive parents sign the affidavit. And if at any point in time that young person is not meeting the continuing eligibility criteria, then their eligibility for adoption assistance would end. This population can't come back at 20 and be qualified. But we've looked at the numbers, and we think really the vast majority of young people qualify under the special needs for adoption extension. And so the number of kids that we think might apply in this category is something like 5 to 12 kids a year. It's not a huge number, but it is nice because for those kids, it will really be a benefit. All right, and that is my formal presentation.
Thank you, Em. That was very, very thorough. And the interesting part is we have absolutely no questions that have been asked. So you are covering it all. At this point, I've opened up the chat in order for you folks to type in any outstanding questions they may have. And I'm going to release a poll real quickly at the same time. Let's see if I can find the correct one. There we go, the exit question, and launch that poll to get your feedback on the webinar. Hopefully you all see that. And that question, M, is do you have information now about the Fostering Futures that you did not have before? So far, 9 are yes, 10 are yes, and 0 are no. 11 are yes. 12, climbing. Does anybody want to chat? Does anybody have any questions they'd like to ask that you can type into the box? I will open it up for you to speak. If you would like to raise your hands, I will take you off mute so that you can ask any questions. Hi, Carl. I see that you're on with us. Carl might also want to chime in. So raise your hands if you have anything to say, and I will then unmute you so that you will be able to share with us. Okay, Cindy, I see that you would like to ask a question, so hold on one second. I have to find my way into this part where I can unmute you. Let's see, mute. Oh, where did it go? Hey, Em, can you unshare your screen with me for a minute? Okay. All right, thanks. That will help. Sorry, folks, I am trying to find where this is.
If you want to type the question into the chat or to the question and answer, I can at least be thinking about what I'm going to say.
There you go. Good idea. May have to go into the... It does not seem to want to let me unmute people. So I'm sorry, if you could type in your question, that would be great. I do not seem to be able to unmute you at this point. Another piece of this technology I guess I'll have to learn. So I've got the question here. Oh, the chat is disabled, Tracy is telling me. Well, good to know, but that doesn't tell me how to undisable it or disable it or open it. So I'm sorry that I am inept at that particular point because we haven't never used this one before. Audio options, here we go. Let's see. Nope. Sorry, let's just get your questions. I can't disable the chat.
So I see a response here from Jill saying how helpful the information was. I really appreciate that, Jill. Thank you.
And Cynthia, I think you had a question. Oh, this is a lot of information to digest. Can we get a copy of the PowerPoint? Cindy, we will be putting this PowerPoint on our YouTube channel and posting it onto our website and onto the Facebook page. So you will be able to get the whole webinar from there.
Kate, I'll provide you with the PowerPoint as well. So you can, we can post the webinar so people can watch the webinar if they miss it tonight, but I'll also make the PowerPoint available so that people can just look at the PowerPoint if they want to. Okay, how will Fostering Futures work for youth and Medicaid coverage? Will they have to request an MCO change? So all of the young people who are coming into Fostering Futures are going to switch to Medicaid to 26, which is the coverage that's available for youth who turn 18 in foster care. They will then continue to be eligible for that Medicaid coverage until they turn 26, whether or not they're in the Fostering Futures program. So we made a decision to do it that way so they don't have to switch back and forth depending on whether they're in the program or they exit the program or come back into the program. They'll enter Medicaid to 26 coverage and they'll maintain it. So I have to say I'm not 100% clear about the MCO. If they're in an MCO in the area where they're going to continue to live, I think they can stay with that MCO. But what does change is after they turn 18, the communication about the MCOs and the decisions that have to be made are communicated directly to the young person rather than the foster parent or the worker. Does Medicaid to 26 work for youth adopted as teens as well? No, Medicaid to 26 is for youth in foster care.
The Medicaid to 26 is for also for the youth who didn't get adopted, right? And aged
Yes.
out here.
Yeah.
Okay.
Yeah, the question is, does it work for adopted kids? The idea, The idea behind Medicaid to 26 is that it's a safety net for young people who did not find adoptive parents while in foster care, so they can have the same access to medical coverage that young people are afforded who are covered under their parents' plans.
All right, I don't see any more questions. Does anybody else want to raise their hand? Carl, you're on. Is there anything you would like to let people know? You can type it to us because I can't hear you, although I have allow viewer chat opened. Carl, I'm going to promote you to panelist so that if you have something to say, you can.
For those of you still on the webinar, Carl is my boss. He's the director of the Division of Family Services. Oh, you've been there, you're added. Maybe.
Carl? Well, perhaps he doesn't have anything to say to us tonight. But he is here. Okay, everyone. Well, I think that answers all of their questions. Thank you very much, Em. It's very much appreciated. And we will talk to all of you on another webinar, which we will try to have one next month. One of the things we're thinking about having as our webinar next month are questions regarding the guardian ad litem for children in care. We have a guardian ad litem who has offered to do a Q&A session for people about the guardian ad litem system.
Oh, nice.
Okay. Thanks, everybody, and thank you, Em, and thank you, Carl.